what we're talking about today, the focus is around chief and council accountability. And so I wanted to just kind of start the session by looking at what is accountability. So accountability is defined in the Merriam-Webster dictionary online as an obligation or willingness to accept responsibility or to account for one's actions. In the Cambridge Online Dictionary, which is an English version of a dictionary, it says the fact of being responsible for what you do and being able to give a satisfactory reason for it, or the degree to which it happens. So what we want to do is talk about what type of accountability framework Witset would like to see incorporated into its custom election code. When we talk about the different components of accountability framework, what we're talking about is a structured approach that Witset can use to hold its chief and council responsible for their actions and decisions, and way to hold them accountable. And there's a couple of different reasons to do this, and it's also to support chief and council. It's not just to shame or make, point out mistakes that they make. It's to enhance their performance over time. So when something happens, everybody gets to have open discussion about it. It gets to be something that's not just shoved under the rug and forgot about it, and then people build up resentment around things. So if you can enhance performance by having those discussions. You can promote transparency around dealing headfirst with issues that arise. You can make it so that all chief and council members know about how to do good decision making. If a mistake is made by one person, perhaps in decision making, how does that get remedied in a way that improves all of chief and council decision making? We can reduce inefficiencies in the way that chief and council operate and make sure that they're responsive to Witset members' needs by having this accountability framework in place. And the different components of the accountability framework are to have open talk that we need to talk about is the openness of meetings. Who will be allowed to attend and observe chief and council meetings? How secretive can they be? Also, chief and council reporting to members. And so this happens in the annual report right now, but is there other ways that reporting should occur? Today, I don't know if we'll get to that piece of the topic. I don't have it as a topic for the community engagement virtual sessions because we have a little bit of a shorter period of time for these sessions, but hopefully we'll get to that if there's time at the end. We'll talk about standards of chief and council conduct and how are members answerable to Witset, or sorry, how are Witset chief and council answerable to Witset members. And that's the piece that we'll talk about in the next meeting, which is around what happens when some sort of misconduct does occur. How do we address it? And so all together, these things make up a framework for accountability. So with the first topic being around openness of chief and council business, we're going to talk about the Indian Act and the First Nations Election Act approaches to this. And then I will give some comparisons to how things work in the federal government, the provincial government, and municipal governments. So the township of Smithers, for example. We'll also look at Wet'suwet'en considerations. So how does the way that the feast hall operates inform the way that you maybe want to have things drafted into the custom election code? And then we'll have discussion around what you want to have in your election code with regard to openness of chief and council business. So under the Indian Act, there are Indian Band Council procedure regulations, and they apply to all First Nations that have their elections under the Indian Act. And basically what they say is that the regular meetings of chief and council are to be open to members of the band, and that the only time that chief and council can exclude a member of the band from their meeting is for improper conduct. And so in those cases, the presiding officer, who is generally the chief, can expel or exclude a person from the meeting because they're causing a disturbance. These sections of the Band Council procedure regulations are generally not what councils follow. They have their own approaches to going in camera, but their approaches to going in camera are actually in conflict quite often with these regulations, and most people don't know these regulations exist. So welcome to the small world of people in the know. If Witset were to, by Band Council resolution, decide that it wants to be under the First Nations Election Act instead of the Indian Act, then it's silent on the issue of openness of council work. Now we're moving on to how things work with regards to openness in the federal government system. So in the House, which is where all the people that you vote in to represent you in the federal government come together, they make laws and they discuss the affairs of Canada. When that's occurring, it's open to the public. So the public can attend those meetings, and it's webcast and recorded, and then it's archived for public viewing. So that's all available on the Canadian government, on the Canadian Parliament website, and anybody can watch that. And I'm pretty sure you've probably seen this where you turn the TV channel and there's some boring government stuff going on and you see it. So that's when it's being webcasted. When members who you vote into Parliament sit on committees and they participate in studying different things like the spending of a government department, or they're looking at a particular proposed law that's going forward and they want to consider different issues that might come as a result of that law, things like that, when they meet in committee to have more kind of specific topic-specific discussions. Those meetings are also open to the public, but they can sometimes be held in camera, and they are also often, most often, webcast recorded and archived. When they attend diplomatic meetings and events, of course, those are happening quite often in the public eye, so you're able to see the conduct of your members of Parliament in those situations. When you look at how things operate, when you consider the way that members of your BC government who you vote into power operate, when they sit in the House and discuss whether or not to pass laws, when they receive reports from committees about different topics of related to lawmaking, for example, when they have their question periods from the when they have their question periods from the opposition, and when they're discussing anything, these things are again televised, webcast, and archived for public viewing. So you can go back and watch them. They're available even if you couldn't attend in person, or even if you couldn't attend by television. So in committees, the public can be present, but this is only with permission, and you have to seek permission from the chair of the committee. But again, being able to watch it on TV or have it webcast and archived for public viewing later, that is a part of the normal process. When you look at how things work with municipal governments and their council meetings, so these are your mayors and councillors, there's a general rule set out in the Community Charter for British Columbia, which is a provincial law, that says that council meetings are open to the public. And then it sets out some exceptions to that general rule. There are some situations where council may make part of its meetings closed to the public. And then there are also circumstances where council meetings are deemed to be closed to the public. So there's kind of this big umbrella rule that says it's all open to the public, and then it says unless council decides to make it closed because of A, B, C, D, E, or unless it's deemed otherwise under the community charter to be closed to the public. Now, some of the situations where it has to be closed to the public, or I should say all of the situations, because I haven't missed any out of the law in here, include when there's a Freedom of Information and Protection of Privacy Act request, and the council is designated as the head of a local public body for the purpose of legislation related to that request. And so in this case, the council is making a decision on whether to release certain documents that are within the care and control of the municipality to somebody in the public who has requested it. That would be dealt with behind closed doors. Also, if they are receiving or negotiating with regards to a relationship between them and a provincial government or federal government, those can be behind closed doors. If it's a matter being investigated under the Ombudsperson Act and the council is involved in that investigation, then that's behind closed doors. And what the Ombudsperson Act does is it conducts investigations into situations where members of the public have said that they have been treated unfairly by a government department. So there's example might be that they were treated unfairly by the Ministry of Children and Family Development, that they were treated unfairly by the Ministry of Environment or Ministry of Social Development with regards to maybe benefits they applied for. Those are the types of things that, with regards to fairness, can be brought to the ombudsperson. And then if there's another law, so the government can also create additional laws that say that the public is excluded from a meeting. So there might be other BC laws out there that are very topic specific. And with regards to that topic, in that law, it says that the meeting is closed to the public, then that would be the case there. Then there's all these situations where the council of a municipality can make a decision to close their meetings to the public. So this is a discretionary decision that the council makes on a case-by-case basis. And I just have a list here that I won't go through in great detail, but I'll just touch on things. So basically, if they're talking about individual who they're looking to appoint as an employee, or they're looking at something with regards to somebody's employment, then they can close that part of the meeting to the public. If they are talking about security of the property of the municipality, maybe they're talking about security systems at City Hall, for example. If they are looking at purchasing or expropriating, so that means taking land from a private person without their consent, but in alignment with specific rules and legislation, then they can withhold that part of a meeting from the public if they are concerned about harm to the interests of the municipality. If there is a investigation, a law enforcement investigation, that might be private, or other types of litigation, either in, BC Supreme Court, provincial court, or even in tribunals like the Human Rights Tribunal or the Workers' Compensation Appeals Tribunal. So there might be other tribunal proceedings that they want to keep from the public. There's a couple more here. So basically any legal advice that they're receiving and information that is protected under privacy laws, any negotiations that have to do with municipal service that are at the preliminary stages. So maybe this is with regards to maybe an agreement with BC Hydro or, some other kind of gas or hydro or services that get provided to the public. If they are talking with other employees about preparing the annual report, and again, if there's another law in BC that says they can exclude you from that meeting at their discretion. So the list here is quite long of times where the council can, at their own discretion, say this is going to be a private affair. We will talk at the end of meeting. We'll come back to the question of Wet'suwet'en considerations. What do the Wet'suwet'en stories and songs and language and laws and oral traditions tell us about how our leaders conduct themselves with regards to us knowing what they are up to as Wet'suwet'en people? So how do our leaders, for example, our chiefs, conduct themselves and do things so that Wet'suwet'en members have access to information, for example, about what's going on in their clan group? And how do we then incorporate some of those underlying ways of being into the custom election code with regard to how chief and council operate? And so how open should council meetings be, and should council have the power to go in camera? Also, what should the rules be around Witset members having access to council meeting minutes or archived webinars, things like that? Okay. So that's the end of the piece on openness, and I just need to skip ahead to another section of slides, so just give me 1 minute, please. I have a slide number here to go to. Haha. 35 after 27 I'm supposed to be at. I went past it. Give me a second. Thank you very much for your patience. Okay. So the next topic is around standards for chief and council conduct with regards to what's currently in place and what would you like to see in place as a community? And there's currently 2 key documents that set out how things work right now. And we'll talk about also how things work in other jurisdictions, just as comparisons. And then again, coming back to those Wet'suwet'en legal traditions and ways of being, and looking at what Witset wants to have in its election code. So we'll start with the more, it's still, the legal name for the document is still Morristown First Nation Financial Administration Law. And then there's a governance policy as well. And this is where we start talking about conflicts of interest and code of conduct and how those things fit in here to what we're doing with the custom election code. So the financial administration law gives a definition of a conflict of interest, and it talks about conflict of interest existing when there's a counselor who has a private interest that is real, potential, or perceived, that is direct or indirect, and it could be a personal interest or a financial interest, and it competes or appears to compete with the interest of Witset or the objective exercise of their powers, duties, functions, and responsibilities. So this is in section 42, subsection 1 of the financial administration law. It's a pretty loaded definition, but if you break it down, it's real, potential, or perceived interest. It could be direct or indirect. If you just break it down into pieces, it's easier to follow. And then you're looking at what is a, private interests include. It includes not only the interests of the individual counselor, but also the interests of their spouse or their dependent children. But it does not include interests that all members share, or that is so remote or insignificant that it can't be reasonably regarded as likely to influence them. So this kind of shared interest, for example, would be if council was making a decision and the decision was about distribution of Christmas support checks, or, money for students, and this counselor might be a student at the time, but every Witset student or every member is receiving the same benefit, so you wouldn't call that a private interest. But if it was a discussion about, whether or not to contract for Witset to enter into a contract with that counselor's spouse for their spouse to provide services to the band, then that would be a private interest that belongs to that counselor because it includes their spouse or their dependent children. So there's just some examples to kind of give light to what this says in all these words that you see on the screen. So counselors have to disclose all their conflicts of interest, and they are not allowed to accept gifts or benefits except in named circumstances. So those are more like culturally bounded circumstances, like you're presenting at you're presenting to a classroom and somebody gives you a small gift, and there's a list of those named circumstances in the financial administration law. And then it also sets out procedures for the disclosure and conduct regarding conflicts of interest. So what does a person who's a counselor or chief have to do once they disclose their conflict of interest? Some of the things include not participating in those discussions any further, not voting on the outcome of the question before them, and basically stepping away from the situation and not doing anything that could influence the situation. And then counselors also have duties to maintain as confidential all information that they receive. So these are their confidentiality duties. So unless the information they receive is generally available to members of the public, for example, maybe they received the information at a band council meeting, and even if nobody attended that band council meeting, it's technically available to members of Witset to have attended, so they could share that with Witset still. The next document that talks about things like conduct and conflicts of interest, etc., is the Witset First Nation Governance Policy. This was last reviewed in 2019. And in that policy, it sets out that the executive director is responsible for ensuring the code of conduct is provided to counselors in a timely manner. And then it points to some financial administration law standards that are put forward by the First Nations Financial Management Board. And it points to them, but it doesn't specifically say that they apply. So there's maybe a little bit of a gap there that's an easy fix. And then basically those standards state that council will establish a policy and procedure around the avoidance and mitigation of conflicts of interest, conduct expectations under the Witset financial administration law. So that's in place already, right? And the governance policy also sets out procedures for chief and councillor reporting of remuneration and expenses. So that's reporting of money that they receive from Witset for activities that they perform on behalf of Witset and expenses that they receive in reimbursement for. So let's compare this to other jurisdictions, and we'll look at federal, provincial, and municipal again. In the federal context, there's a Conflict of Interest Act. And what it does is it creates an Office of the Conflict of Interest and Ethics Commissioner. And the person in that office is mandated to make decisions about what measures are necessary to avoid conflicts of interest and to determine whether conflict of interests contraventions occurred. In that legislation, it encourages people to seek and accept public office and facilitate exchange between the public and private sector. Those are the kind of underlying reasons why they want to address conflict of interest issues. It sets out prohibited activities. So this is very specific. It's a little bit different of an approach than what is in the financial administration law right now. It's prohibited activities would include providing preferential treatment to people, using information for your private interest that's not available to the public, using your position to influence decisions that benefit you privately, being influenced in the way you exercise your duties by offers of outside employment, accepting gifts and other things that could be seen to have been given to you to influence how you exercise your duties, entering into contracts and employment relationships in the exercise of official duties with somebody who is related to you, essentially. So, for example, you're allowed to hire somebody to help out with an event, and you hire your spouse. Individual people would not be allowed to do that in this context. And then personally soliciting funds if it places you in a conflict of interests. And if these things do occur, then a public office holder, so they would need to recuse themselves from discussions, decisions, and debates and not vote on them. So that's very similar to how the financial administration law process is. The Conflicts of Interest Commissioner has powers to investigate alleged conflicts of interest, either on their own or if they have reason to believe that somebody has engaged in a conflict of interest. And they can give penalties of up to $500 for failure to report. And also they can take other compliance measures that they determine necessary, which is a very broad power. Moving on to the provincial context, when you're dealing with conflicts of interests, there's a Members Conflict of Interest Act that applies to all people who are voted into our provincial legislature. And so a member is a person who you voted into office. So a member has a conflict of interest. It defines, again, conflict of interest, says that a member must not exercise official powers or perform official duties or functions if they have a conflict of interest or apparent conflict of interest, and that they must not use information gained in their office to further their own private interests. And then they cannot also use their office to seek influence on a decision. They can't accept fees, gifts, or personal benefits. And there's limits on when a former member, so somebody who used to be a member, can be given a contract or benefit from government. And then there's restrictions on members on their abilities to engage in outside employment, business, and other positions that could create conflicts of interest. And then they have procedures and enforcement powers, so procedural requirements to disclose, and if they fail to comply with their duties, The government may void the transaction within 2 years of it occurring. So, for example, if they granted themselves or their family members a contract, they could void that contract. People could have to pay back through Supreme Court of BC application any financial gain, and then could be an inquiry into what happened as well. So in addition to conflicts of interests law, the Legislative Assembly of BC has different policies that address the rules and procedures for chief and council around internet technology, financial decision-making, and member conduct. So their code of conduct essentially is in the Legislative Assembly of BC policy manual. And that sets out what wrongdoing is, talks about respectful workplace behaviors, etc. And in that policy, it defines wrongdoing. So when we're looking now at, we're moving into that world of what is misconduct. Misconduct would be a serious act or failure to act by an employee or employees of the Legislative Assembly that, if proven, would be an offense under the law. So now we're talking about employees of Legislative Assembly, not about the members themselves in this case. And then the act or failure to act that creates substantial and specific danger to the life, health, or safety of persons or to the Legislative Assembly, serious misuses of funds or assets, gross and systemic management of the administration, and directing and counseling people to commit the same. And then there are policies on reporting suspected wrongdoing. And basically, it's an independent and arm's length third party that gets appointed as the person to receive disclosures. And then they conduct investigations and report findings to the clerk of the Legislative Assembly about misconduct having occurred. And then the clerk of the Legislative Assembly decides on what the disciplinary measures are going to be. When it comes to municipalities, there is a bit of a different approach, and this is an approach that a lot of banzai find they find this attractive with regards to code of conduct. And basically, the approach is that they trust their council to establish and maintain a code of conduct, and they're okay with the council themselves making that decision as long as the process for doing so is transparent and there's regular reviews and the review process is transparent. So the Union of BC Municipalities provides model codes of conduct to each municipality, and then there are different enforcement options that are included in that. And the municipality itself has to maintain their own code of conduct. And if it decides not to do so, then it has to make a public statement on its reason for not doing so. Maybe it's that they're okay with the existing code of conduct. And then every year before January 1st, they have to review that decision. So what is in the code of conduct? How do you apply and interpret a code of conduct? Foundational principles of responsible conduct, standards of conduct, and enforcement measures. Those are all the things that the municipality has to maintain in its policy. And then they have additional policies that are related to this, but not direct, that they have to maintain. And then, where are we? So basically, I'm going to stop sharing now. Oh, maybe do I have questions up here? Give me a second. Oh, yeah. So basically, Witset considerations that we need to keep in mind when we're looking at how we want things to be managed in the areas of code of conduct, conflict of interest, and deciding what misconduct is. We want to look at what Witset stories, songs, language, laws, and oral traditions teach us about standards of conduct that we expect out of our chiefs and where those standards come from. And we want to think about that and how to incorporate it into custom election code. So the question becomes, after thinking about those Witset considerations, what does Witset want to see in the election code around the standards of conduct for its chief and council?